Vamos dar continuidade, então, à nossa próxima atividade. E compõe a mesa nesta atividade o excelentíssimo desembargador Roberto Basilone Leite. Para falar sobre precedentes no sistema jurisdicional americano, o excelentíssimo juiz distrital federal de Maryland, Estados Unidos, George Hazel. Com a palavra, o desembargador Roberto Basilone Leite.
Boa tarde a todos. Então, vamos nos encaminhando para a última exposição. Então, vamos partir aqui para mais uma análise comparativa, agora com o sistema norte-americano. E o Dr. George Hazel, então, como já foi sintetizado, é juiz federal de primeira instância do Tribunal Distrital dos Estados Unidos, circunscrição de Maryland. É doutor em jurisprudência pelo Centro Universitário de Direito da Universidade Georgetown de Washington. Foi vice-procurador estadual em Maryland, capital do estado, em Baltimore, capital do estado de Maryland, entre 2010 e 2014. Foi assistente da Procuradoria na circunscrição de Maryland até 2010 e assistente da Procuradoria em Colômbia entre 2005 e 2008. Também atuou como advogado entre os anos de 99 e 2004. E ele foi... tem uma curiosidade que ele foi o juiz mais jovem, the more youngest, juiz federal designado na respectiva gestão pelo presidente Obama, e um dos mais jovens da história da Justiça Federal dos Estados Unidos. Então, sem maiores delongas, eu passo a palavra, então, Dr. George, please. You.
Good afternoon. Can everyone hear me? All right. So I should say at the outset that because of a problem with my flight on Tuesday evening, I didn't fly out of the United States until last night and arrived here around lunchtime today, went to the hotel, and came straight here. So while you probably already know that I don't speak Portuguese, I'm actually a little concerned about my ability to speak English coherently this afternoon. So hopefully you'll bear with me. I've told my interpreter that if I start to ramble and say things that don't make sense, she has my permission to just fill in words that make more sense to you all in Portuguese, so that she's the only one that knows I'm not actually making sense up here. So with that being established, we can move forward. First, let me just take a moment to say thank you thank you for the opportunity to speak here today on behalf of the American judiciary. Usually at such a program, I would start off by first just acknowledging all the distinguished people that we have here, but simply by looking around the room, by the people I've already met, if I were to stop to do that, I would have to acknowledge each and every person here, because I understand that we have a room simply full of distinguished individuals, many of whom I've now had the opportunity to meet in person. So let me just say that I was asked by many of my colleagues to simply just bring the warm greetings of the American judiciary here to you today. And again, we are all honored that you would invite us as a nation, and then certainly me as an individual, to participate today. It is certainly my honor to participate in this program. It's my hope that through the speaking, I'll have the opportunity to share, but even more importantly, at the end, we'll leave some time for question and answers. It's certainly my hope that I'll learn from you, frankly, probably much more than you learn from me, as we simply share our experiences trying to administer justice in our respective countries. So I've been asked to address two main topics. I am going to try to slow down just a little bit for the benefit of interpretation. The two topics I've been asked to address are resolution of employment conflict in the United States and the use of precedent in the United States. So I'm going to speak first about employment conflict before moving into precedent. So the first and probably the most significant distinction between our system and the system in Brazil as it relates to the resolution of employment conflict is that in the United States, we actually don't have a separate federal court for labor disputes. In fact, there really is no centralized process or venue in the United States for dealing with labor disputes. Even defining exactly what's meant by labor would be a little more challenging in the US system. The phrase employment conflict is broader and covers more ground, including some areas that may speak to areas beyond what you would deal with in your labor court. But to the extent there are any such disputes simply between an employer on the one hand and an employee on the other hand that make their way into a federal court, in the United States, those cases are handled originally by United States district judges, who are trial judges just like me, as part of our general caseload. There's no separate labor caseload for federal judges in the United States. That being said, disputes between employers on the one hand and employees do take up a significant portion of our caseload. Now, in the United States, when I speak of employment conflict in federal court, I'm really referring to two forms that we see most often. And I think one you see more often in your labor court, one you probably don't see in labor court, as I understand your system. But for us, the first thing we think of when we think of employee conflict are when an employee claims that they've been a victim of some form of discrimination by an employer based on a classification such as race, gender, or nationality. Now, I understand, again, having taken some time to try to get a better understanding of your labor courts, I understand most of those cases might not actually come in under the heading of labor court. But as we think about employment conflict, that's certainly a large part of what we see. Just as an example, at the end of 2016, we had 223 such cases pending in the District of Maryland, and that made up about 6% of our overall caseload. We also have cases that fall under our Fair Labor Standard Act. That is a law that prescribes certain rules that employers are supposed to follow regarding wages, specifically the payment of a minimum wage and overtime. At the end of 2016, there were 467 such cases that were pending in our courthouse, and that made up 13% of our docket. Now, to put that in some context, a typical judge in my court has about 250 civil cases. We might have, in addition to that, another 40 or 50 criminal cases, because again, district judges in the United States are generalists. We don't have separate dockets. So a typical docket might be 250 to 300 civil cases, around 50 criminal cases. So when I say there are 467 cases in our court dealing with Fair Labor Standard Act issue, I mean, we could, if someone were to decide it was more beneficial, we could separate them out and have a judge or two just focused on those issues. But that's simply not how we've done it so far. So in total, about 20% or 1/5 of our court's dockets are made up of cases that involve some form of employment conflict. Now, in part, to keep federal courts from being flooded with employment cases, there are requirements that we've put in place that a plaintiff must first meet before they can even come into court. Primarily in a discrimination context, they must first bring their claim to what's called our Equal Employment Opportunity Commission. It's referred to as the EEOC. And that agency has a number of roles, but included in their role is responsibility for intake, for investigation, and for conciliation of claims brought under the Civil Rights Act or the American with Disabilities Act, which includes employment discrimination claims. And the EEOC offers the opportunity at the initial instance for some mediation and hopes to resolve those claims before they ever make their way into court. Now, if a plaintiff actually does not bring their claim before the EEOC first, the claim will actually be dismissed in federal court because we'll say that they have failed to exhaust all possible administrative remedies. That is to say, in the United States, before you can bring a federal claim, you must first seek and make use of whatever administrative remedies are available to you. And the law in this area is actually quite strict. Not only must you first bring the claim to the EEOC, but you cannot then bring one type of claim to the EEOC and then try to add additional charges in front of the federal court later. So for example, you cannot go to the EEOC and say I was discriminated on the basis of gender, bring that case in front of the EEOC, and then later come to federal court and say, oh, I was discriminated against because of race as well. You would probably be limited to the claim that you brought in front of the EEOC. And the purpose of that is probably clear, is because we want the opportunity for the employer to resolve the issue before it gets into federal court, thereby allowing us to conserve resources. Now, in the context of wage-related litigation, there is also a federal agency that often, but does not always, get involved prior to litigation in federal court. In that context, it's the Labor Department. But it's important to understand that in this area, employees can still sue even without the requirement to exhaust their administrative remedies, as I discussed in the discrimination context. And when they sue under the Fair Labor Standards Act, known as the FLSA, those cases come into federal court. It's important to note, however, that most states also have their own wage and hour laws. And so while federal law provides the floor, as we say, for what employers must provide their employees in terms of a minimum wage, some states actually have laws requiring higher minimum wage than what the federal standard is. And so as a result of that, you will often have situations where a plaintiff will bring their case in state court under state law rather than coming into federal court with a federal claim. Now, as I'm sure you're aware as labor court judges, these are tremendously important cases that carry with them significant policy implications. For the worker, we're dealing with the ability for them to be paid at least a minimum wage, overtime where deserved, so that they can support a family. It is very hard, and I'm sure it's true everywhere, but it's very hard even on minimum wage in our country to be able to support your family in a way that most people would like to. And there's certainly an imbalance of power between employer and employee that without oversight could allow the employee to become abused by an employer. By the same token, we recognize that there are some companies not making huge profits who are barely making enough money to pay the salaries that they're paying, and so they need to have some limits self-imposed on how much they can pay in salary and still remain in business. And so there are these balances that Congress has tried to consider, and the courts certainly try to make sure the laws are implemented in a way that addresses that. But even recognizing the importance of these cases, they can be somewhat burdensome on the courts, and an individual case under the FLSA often takes up more of the court's time than an individual case does under different federal statutes. So just to give an example, and throughout the presentation, and what I hope will be helpful, I'm going to sprinkle in some examples from either my own experiences or some of my colleagues to just give some nut and bolts examples. So I had one case that went to trial before me a couple of years ago. It involved a restaurant worker who claimed she had not been paid overtime or minimum wages. And this had lasted over a number of years. It was a bench trial, and when I say bench trial in the United States, that means as opposed to a jury trial where we have a group of citizens, 6, 8, or 12, depending on the type of case, decide the case. In a bench trial, the judge actually acts as finder of fact and makes that determination. So it was up to me as the judge in a bench trial to make a determination as to whether the defendant owed the plaintiff back wages and overtime for payments not previously made. Well, as is the case with most lawyers and judges, one of the primary reasons I went to law school is because they had promised me there'd be no math involved in the work. But trial ultimately came down to calculations involving the difference between what she would be paid an hour and what she was paid an hour, multiplied by the number I had calculated as the number of hours she had worked for less than minimum wage, and so on. So these cases can become more about mathematical computations than they actually are about the law. And I can see from some of the head nodding that it's probably true here as well. And even resolving these cases at the settlement stages in the United States actually can take more. I thought I heard someone say something. Okay. Even resolving these cases can take more judicial resources, as some courts have found that settlements under the Fair Labor Standards Act require more careful judicial review than cases in other contexts. So, for example, a settlement under the FLSA in our courts requires the court find that there was actually a legitimate dispute. That is to say that there was at least some basis for the employer to argue that the claimed wages were not actually owed. We have to decide if the settlement was reasonable given the facts, and also determine whether the attorney's fees, which are often part of the settlement, were actually fair. These are things that we actually don't usually have to do in other contexts. But again, precedent has developed, and we'll talk about precedent in a little bit. Precedent has developed indicating that courts should do that again because of the imbalance in power between an employer and an employee. So that's why we rely on agencies to enact regulations clear enough to give detailed instruction. Most other cases that would be addressed in your labor courts are actually handled by administrative agencies in the United States. So, for example, we have the National Labor Relations Board, which enforces regulations involving the rights of unions, requiring private employers to deal with unions and prohibiting discrimination against union workers. We have the Occupational Safety and Health Administration, concerned with workplace safety and health. And we have the Employee Benefits Safety Administration, which requires or regulates employers who offer pension or welfare benefit plans for their employees. In all of these administrative agencies, there is some recourse to civil courts, but the vast majority of these claims get resolved in the United States at the administrative level. So as you can see, our system for handling labor disputes is different than yours, as most of our disputes between employers and employees are handled through administrative agency. So next, I do want to discuss, and I'll focus more time on this issue of precedent. And I have come to learn this is an issue of growing importance in your courts and throughout Brazil as a result of a relatively recently enacted Code of Civil Procedure, which has embraced the concept of precedent, which is generally understood as meaning that inferior courts are obligated to follow certain decisions of superior courts. So one initial distinction between Brazil and the United States is that we actually don't have a statute that establishes what a precedent is or how it is to be applied. In the American system, the issue of precedent, or stare decisis, is simply a concept that is developed over time throughout common law traditions. The reasons for Americans' development of a system based on precedent are likely the same that have brought you to that place. Reliance on precedent, one, provides efficiency so that courts are not being required to decide the same issue over and over and over again. It might still happen, but perhaps with less frequency. It also provides some degree of certainty and predictability, allowing our citizens to have some ability to predict how courts will determine their rights and responsibilities in our respective countries. So to understand precedent in the American system, you must first understand the way that our court system is actually set up. Much like you, we have a state system on the one hand and a federal system on the other. Each of the 50 states that make up the United States has its own state court system. Each state system is their own creation, and they use different titles to describe their courts. Sometimes it actually gets confusing. In some states, the state Supreme Court is their highest court. That's the highest court in their state. But in New York, for instance, the state Supreme Court, when you refer to their state Supreme Court, you're actually referring to one of their inferior courts. But generally speaking, the design of the system is similar to what you have here, in that you have a trial court with one or more appellate courts on top. A typical state system is what you find in the state of Maryland, where the lowest level court there is referred to as the district court. You have a circuit court that handles appeals from the district court and also has original jurisdiction over more serious cases. You have the Court of Special Appeals that hears appeals from the circuit court. and a court of appeals that hears appeals from that court. And from there, a losing party can seek review with the United States Supreme Court. So there you have the district court, circuit court, court of special appeals, court of appeals, with a final appeal to the United States Supreme Court. Federal jurisdiction, on the other hand, is limited, so most cases are heard before state courts. But on the federal side, in every federal district, there are district judges, and again, that's what we call our trial judges, who have original jurisdiction. A case is appealed from the district judge to a circuit court of appeals. We have 13 different circuit court of appeals in the federal system. Most of them review federal cases coming out of just 4 or 5 states each. So for example, the court where I sit is part of the Fourth Circuit. The Fourth Circuit Court of Appeals reviews cases that come from the Federal District Court in Maryland, Virginia, North and South Carolina, and West Virginia. Appeals from a Circuit Court of Appeal then goes to the Supreme Court. So in the federal system, you have the District Court, Court of Appeals, United States Supreme Court. The one common instance between state court and federal court is that you have the United States Court of Appeals sitting on top of both. Now, unlike your Supreme Federal Tribunal, which I understand can hear thousands of cases a year, our United States Supreme Court only decides roughly 60 to 100 cases a year. So our Circuit Court of Appeals resolve the vast majority of our appealed cases and, frankly, create the bulk of what we rely on as precedent. While the Supreme Court typically resolves issues of national significance or issues where the Court of Appeals have reached differing conclusions from each other. Now, the reason I take the time to make sure you understand the relative positions of our court is because that then determines which court's rulings are binding precedent on which other courts. And when I use the phrase binding precedent, I mean precedent that a court is obligated to follow. As a starting point, the one court whose rulings act as binding precedent for all other courts is the United States Supreme Court. Because, as I've explained, all other courts, be they state or federally, ultimately have their cases appealed to the Supreme Court. Thus, the Supreme Court is the only court whose rulings act as binding precedent on all other courts throughout our country. For courts other than the U.S. Supreme Court, rulings are only binding precedent on the courts that are directly below them. So, for example, rulings of the Fourth Circuit Court of Appeals are binding precedent only for the federal district courts in the 4 or 5 states that make up the Fourth Circuit. A slight exception to that is when, on occasion, a circuit court might decide not to, as we say, publish one of their opinions. That means as a technical matter, it's not binding, although most lower courts would still follow it, as it can be predictive of what the Fourth Circuit would do if you had a case in front of you that were to be appealed to the Fourth Circuit. And I should make clear that the idea of a distinction between published and unpublished decisions is really somewhat of an old-fashioned concept now. Historically, opinions were published in textbooks, and that was the only way you read opinions from the court. And so if an opinion was not published, people would not read it other than the litigants involved in the case. Now in the United States, we have all of our opinions are online and accessible through electronic databases. So we all have access to every opinion that any court asserts, whether they consider it published or unpublished. So at this point, even unpublished decisions, because they are widely spread, are still going to be cited, and most courts underneath them are still going to rely on them. But I stopped to make that point, though, because it is still a distinction between how we do things and what you refer to, and I'm going to try to use the word here, although I won't pronounce it correctly, the summa vinculanti. I'm sure the interpreter pronounced it right, so I should have just said it in English. But there is no requirement in our system that a superior court explicitly declare that it's creating precedent, or only do so by some special vote that the decision will be binding on others. Simply by ruling on an issue, the U.S. Supreme Court creates precedent. And the Circuit Court of Appeals will generally publish any opinion that speaks to an issue that they have not previously resolved. They really usually only use the unpublished designation if they're ruling on an issue that they felt like they've really already addressed in the past. So as I mentioned, Fourth Circuit Court of Appeals sits on top of my court, and I must listen to their rulings. Rulings from other circuit courts, such as the Ninth Circuit as example, sits over California, doesn't bind me. Likewise, even the highest state court in Maryland cannot issue precedent as a general matter that binds me. The one exception that I note for you in that regard that I think is an important one is that if our Maryland state court interprets a Maryland state law issue, that is, their interpretation of the Maryland Constitution or their interpretation of Maryland state legislation, then that interpretation is actually controlling in federal court. So if the same question then arises in my court, I am supposed to give the highest Maryland court's interpretation of that Maryland state law issue controlling impact in my court. But even in that situation, if one of the parties believes I am incorrect, they still would not appeal my decision to the Maryland State Court. They would still appeal the decision to the Fourth Circuit Court of Appeals, and they would then determine whether I had interpreted the law correctly. So that is binding precedent. That's precedent that I am required to follow. We also have what I will call and what we call persuasive authority. Persuasive authority is a ruling from another court that may be cited to me and that I might decide to follow, but I'm not required to follow it. So for example, I might have an issue that I am deciding, and after doing some research and reading the briefs, I see that neither the United States Supreme Court or the Fourth Circuit has directly spoken to it. And because those are the only two courts that can issue precedent that's binding on me, there is no binding precedent in that case. But there might be a decision on that exact issue that was made by, say, the Fifth Circuit Court of Appeals, or even one of my brother and sister district courts. Well, that decision would not bind me. That is to say, I wouldn't be required to follow it, but a lawyer could and often would cite it to me, and I would review it. And if I thought the analysis were persuasive, I could certainly choose to follow it. And so we refer to that as persuasive authority. And persuasive authority can come from any number of sources. It can come from fellow district courts. It can come from courts of appeals outside the Fourth Circuit. Even some academic publications that can be trusted sometimes provide for persuasive authority. But the thing to understand there is that its only authority comes from the degree to which it actually persuades the judge. So if I read it and I actually find it persuasive, then I can follow it if I choose to do so, but I'm not required to do so. So for example, there was a case before me recently where a local criminal prosecutor who was white was allegedly fired by the state's attorney because her spouse, who was African American, had been arrested on sexual assault charges. The employee claimed that she had been discriminated against because employees who were married to non-African Americans had been arrested for similar crimes and did not get fired. So she sued under Title VII of our Civil Rights Act, which makes employee discrimination based on race unlawful. The core question was whether a local prosecutor was an employee covered by Title VII or had another unprotected status, such as a policymaker, which was not protected. A fellow district judge in my court had recently decided the question of whether a local prosecutor could be fired for supporting her boss's political adversary, or whether that firing violated a First Amendment right. The relevant common law claim there made a similar distinction between employees on the one hand and policymakers on the other, just as the statute I was reviewing did. The case was cited to me. But as I pointed out in my opinion, first, the ruling of my colleague was not binding on me because it came from a court that was equal to mine, and thus was not binding precedent. It was also factually distinguishable from my case, and so I pointed that out as well. Cases were cited to me from each side, from different circuit courts of appeals throughout the country who had reached different conclusions on the same issue. But because none of the cases was from either the Supreme Court or the Fourth Circuit, I wasn't required to follow any of them. So I took the time and I did a thorough analysis of each case. And I agreed with the case that I found to be most persuasive. And I gave my reasoning for that. Now, I was not required, and I know this becomes an issue in your courts, I was not required to discuss every ruling based on any law. I simply found that that's good practice because the cases were relevant and these issues had been decided by other courts. Now, I know there has been discussion in Brazil about how attorneys cite precedent to the court and how a court must go about addressing that precedent. And as I understand it, the question is whether a court must explain its reasoning for following or not following each and every case that an attorney cites to you as being potentially binding precedent. Well, again, there's no explicit rule to that effect in the United States. However, if there is a case that is directly relevant to the case a judge is deciding, and it was issued by a court that binds the court considering it, it would certainly be expected that the court, in issuing its ruling, would explain why that court decided the precedent was controlling or why it could be distinguished. But generally, judges will simply focus on the most important cases cited and not spend time addressing each and every case that was cited by the parties. So if an attorney cites 20 cases to me in their brief, the court is free to address as it chooses the ones that they feel are most relevant, but is not required to explain why it did or did not follow every single case that's been cited to by the attorney. I do think, however, that it's important to consider that in many ways the development of our laws come through what I refer to as a conversation between judges. And that conversation really takes place in the form of written opinions. One of my colleagues writes an opinion, I address it and I give my thoughts on it in my opinion. Another colleague then addresses it in one of their opinions. By pointing out and highlighting well-reasoned opinions, we further the cause of strong case law, as does, frankly, the occasional respectful disagreement between judges. So for that reason, I and many of my colleagues will sometimes discuss cases, even recognizing that they're not binding precedent, just because it's good practice, and I think it can be a good idea to have the parties understand why you didn't follow a particular case. But again, it's not something that we require of ourselves. Another concern that I know has come up is the practical matter of identifying precedent. In America, we have centralized databases that make it very easy for us to find relevant cases. We simply enter into a database the relevant search terms, and we're able to pull up cases relevant to our case. And there are two primary databases, but both have cases from all American courts, federal and state, all statutes, federal and state, and most regulations. It's frankly, for me, difficult to imagine a system that's so squarely focused on precedent that would not at some point make a concerted effort to try to move toward a similar system where you have easy access to cases throughout your state and country. And again, we're able to do that without searching in different courts. We can go to one place and find cases from courts throughout our country, and it makes that process significantly easier. Even without that, however, there are still times when attorneys fail to cite to relevant cases, notwithstanding the fact that we actually have rules that require our attorneys to do that. Specifically, we have a rule that if a lawyer is aware of a case that is precedent, that opposes the position that they've taken, ethic rules actually require them to tell the court about it. So they can't hide a binding precedent that goes against what they are arguing. But sometimes lawyers just make mistakes and frankly miss some of these cases, and we're left to find them on our own. But the expectation is that relevant issues and precedent will be cited to by the parties. Another question that I know arises in dealing with precedent is whether precedent from a court is the ultimate source of law. Is it legislation from Congress? Is it the Constitution? And the ultimate authority on the law in the United States is the United States Constitution. But our Constitution is much shorter than yours, and it does not cover every possible situation. And so that's why our Congress still has to pass legislation. And provisions of our Constitution often require interpretation. So for example, the Fourth Amendment to the Constitution states that the right of the people to be secure in their person, houses, papers, and effects against unreasonable search and seizure shall not be violated, and warrants shall not issue but upon probable cause, supported by oath or affirmation, describing the place to be searched, and the persons or things to be seized. Now, the Supreme Court cannot overrule the Constitution. So they cannot issue a ruling that would say you don't need probable cause for a search warrant, because the Constitution very squarely says that you do. But the Supreme Court can, and frequently does, interpret what the Constitution means by that. So in the example of the Fourth Amendment, the Supreme Court can and has decided, well, what is a search? What is a seizure? What is probable cause? And when the Supreme Court answers those questions, it becomes precedent that other courts must follow. But then lower courts must go through a similar exercise as we then determine how it applies precedent we've received from the Supreme Court or from any higher court. So just as the Supreme Court is called upon to interpret what the Constitution actually says, often the decision of the Supreme Court itself is then subject to some interpretation. That is to say that a Supreme Court case might be similar to a case before a lower court, but yet still different enough that it might not be easily apparent whether that particular precedent applies here or how it applies. Thus, a lower court must apply precedent, but will often have to interpret exactly how that precedent applies to a specific case. And Congress has a role here as well, as they pass laws that relate to rights granted by the Constitution. So for the example, in the issue of the Fourth Amendment, Congress has passed a law allowing a person to sue government officials in court who violate their constitutional rights. So I'll give you an example where many of these issues were at play. Police officers were called to a particular street because of a report that a male individual was robbing a female. Upon arriving at the scene, he found a couple, male and female, generally matching the description, but instead they pointed down the street and said that two men had attempted to rob them at knife point and run away. Officers drove down the street and found two men generally fitting that description. They were stopped and taken by the police to the ground at gunpoint. A knife was recovered from one of the two men. The couple was brought to the scene and they identified the two men as the individuals who robbed them. When the case came to trial, the victims didn't appear for court, and so the case was dismissed. The two men who had been arrested then brought a civil lawsuit against the police officers, claiming they had been arrested without probable cause in violation of their rights under the Fourth Amendment to the Constitution. So after discovery, I had to decide whether there was enough evidence to allow plaintiff's civil claim to go forward to trial or whether to dismiss it. So my starting point was the United States Constitution and the Fourth Amendment. As I indicated a moment ago, the Fourth Amendment requires that there be probable cause before there can be a seizure. But just reading the text of the Constitution did not tell me whether Mr. Peters, the plaintiff, had been seized or how I was supposed to determine whether or not there's probable cause. Thank you. So I next turned to precedent from the Supreme Court for help in deciding those issues. Now, there are various cases where probable cause has been defined in such a way that it would seem that the officers did not have probable cause when they first came upon the two men and put them on the ground, because at that point, they only had the facts that two people had pointed in that direction and sort of generally described them. But in a very well-known case called Terry versus Ohio, the United States Supreme Court had said that if an officer briefly detains a person for an investigation, then it is not a seizure, and so they do not need probable cause. All that is needed is what called reasonable suspicion that criminal activity has taken place. It's important to note here that you can search the entire text of the Constitution and not find reasonable suspicion. But this Supreme Court holding doesn't conflict with the Constitution. The Constitution says you need probable cause for a seizure. The Supreme Court has said an investigatory stop is not a seizure, and then established what was required for an investigatory stop. In doing so, they create precedent for interpreting the Fourth Amendment. The Supreme Court precedent does not trump the Constitution. Nothing trumps the Constitution. It simply helps us to interpret the Constitution. So I had to apply that precedent to this case. But then the facts of Terry versus Ohio from the Supreme Court were not precisely the same as the case I was trying to decide. So just as I had to look at the Supreme Court's holding in Terry to interpret the Fourth Amendment, I then had to look to the Fourth Circuit Court of Appeals for precedent on how I interpret the Supreme Court's ruling in Terry. And because the Fourth Circuit handles so many more cases, there were many cases for me to look at as I tried to decide. But there was not just one single case for me to look at and determine to be the single case that I could rely on. From time to time, you will have that case where you find one case that's the binding precedent that you can say, yes, because of Hazel versus Jones, I can definitely say this is how the outcome should be in this case. But more often than not, what you're doing is you're grappling with different cases from the Fourth Circuit, trying to decide the parameters of the issue you're looking at. So for example, here, I found a Fourth Circuit case explaining that the fact that the officers in my case drew a gun, that is to say, pulled out a gun and pointed it at the suspect, that, to my surprise, frankly, did not automatically make what had happened an arrest. I found a case indicating that if a stop takes no longer than necessary to either verify or distinguish the officer's suspicion, it can be considered an investigatory stop, and therefore not an arrest or seizure that requires, or not an arrest, I should say, that requires probable cause. I found other cases that spoke to other particular aspects of my case. Applying all of these cases, I found that he had not been arrested, but merely stopped for investigation, that he had reasonable suspicion given the circumstances, and that after the initial stop, they had acquired sufficient information for an arrest. So that's simply an example of how a judge in the United States, and I'm sure it's very similar here, has to work through case precedent while also looking at legislation and also ultimately looking at, as your starting point, the Fourth Amendment. Now, the impact of precedent on laws passed by Congress is similar, but with an important distinction. When Congress passes a law signed by the president, someone can bring a lawsuit saying that the law itself is unconstitutional. And we've seen that happen. One recent example was President Obama, our former president, passed the Affordable Care Act. And that was a case that was challenged multiple times, with the Supreme Court ultimately deciding that it was constitutional. Had they decided otherwise, the Supreme Court would have had the power to invalidate that law passed by Congress. But beyond just determining whether it's constitutional, just like with the Constitution, courts must interpret the laws passed by Congress, and once a court interprets that law, it becomes precedent for courts faced with similar questions. Precedent is often developed slowly over time as a new issue works its way through the judicial system. And this is an area where, again, based on my review of your system, I actually became a little jealous about your approach. There's a statute in the United States known as the Armed Career Criminal Act. It's commonly referred to as the ACC. Now, this is not a part of our Constitution, but was the result of legislation passed by our Congress and signed by the President. The ACC imposes a 15-year mandatory minimum prison sentence on a defendant determined to be an armed career criminal in possession of a firearm. To be an armed career criminal, you must have been convicted 3 times of either a serious controlled substance offense, narcotics, or a crime of violence. But what was not clear in the statute is what actually a crime of violence should be defined as. Those cases came first to the lower courts. Now, as I understand it, you have a process by which cases will have some reaching impact or are going to be looked at by a number of cases, can be certified to a panel for resolution that then bind all similar cases. In the United States, ultimately, cases like the one I described will wind up before higher courts, but the lower courts first have to grapple with these issues individually. So, for example, a number of trial judges had to reach determinations as to whether specific types of crimes were crimes of violence. One trial judge decided that second-degree assault was a crime of violence. Another trial judge said, no, looking at the elements of the offense, I don't think that second-degree assault is a crime of violence. Because the second judge is not bound by the rulings of another trial judge, at that point, we were just left with conflicting decisions from 2 judges whose cases only bind the parties before them. And those numbers grew, with some judges lining up on one side and some judges lining up on another side. It wasn't until the cases were appealed to the Circuit Court of Appeals that we would actually have and did have precedent that would resolve that question and bind lower courts. So in the example I'm discussing, the Fourth Circuit Court of Appeals eventually decided that based on the elements of the crime, second-degree assault was not a crime of violence for purposes of the Armed Career Criminal Act. And so that interpretation then became binding on all courts sitting within the Fourth Circuit. Notwithstanding that, courts outside of the Fourth Circuit still had to grapple with the issue, decide the issue, until those cases wound their way up to the Circuit Courts of Appeals in their district. Now, ultimately, if the court interprets a law passed by Congress that differs from the way our Congress wanted the law to be interpreted, Congress does have the ability to amend the law. And some will often refer to that as Congress overruling a court's precedent. Effectively, what Congress is saying is that the courts got it wrong, and so we are clarifying what we actually wanted when we passed this legislation. I would not refer to that as a court being overruled by Congress. Simply, the system is just functioning the way it's intended to function. Congress creates legislation, the court determines whether it's constitutional, and then applies it as interpreted. If Congress disagrees with how the law is interpreted, then they have the opportunity to clarify the law. One last point, as I recognize that you have been here all day. Some may ask, can precedent be changed once it's been established? The answer is yes, although it's rare. In the case of one of the Circuit Court of Appeals, a court can overrule itself if a later collection of judges on the same court decides that the court had previously gotten an answer wrong. Also, the Supreme Court can overrule its own precedent, although that happens very, very rarely. When it does happen, it's often as a result of changes in societal norms. The most notable example can be found in the relationship between two well-known Supreme Court cases. One is titled Plessy v. Ferguson, which was from 1896, and the other Brown v. the Board of Education, which was issued in 1954. Both involved a doctrine that was known as separate but equal, which served the practical effect of segregating Caucasian citizens from citizens of African descent. Plessy involved passengers on a train. A person who had one great-grandparent of African descent, that is to say that he was 1/8 African American, purchased a first-class ticket on a passenger train. He sat in an area that had been reserved for white passengers. After refusing to move, he was ultimately arrested and litigation followed, with the individual contending that he had been denied both equal protection under the law and due process under the 14th Amendment to the Constitution. The Supreme Court in 1896 upheld the law that had led to this man's arrest, and they stated, quote, "Laws permitting and even requiring their separation in places where they are liable to be brought into contact do not necessarily imply the inferiority of either race to the other, and have been generally, if not universally recognized, as within the competency of state legislatures in the exercise of their police powers." Then, despite the fact that this case did not involve schools, it specifically mentioned segregation in schools and said the most common instance of this is connected with the establishment of separate schools for white and colored children, which have been held to be a valid exercise of the legislative power, even by courts of states, where the political rights of the colored race have been longest and most earnestly enforced. So in 1896, the United States Supreme Court, the most powerful court in our land, established a precedent that laws that imposed racial segregation in public transportation did not violate the 14th Amendment to the Constitution. That was precedent, and any court in the United States faced with a similar law would have to, and at that time did follow that precedent. About half a century later, there was a case called Brown v. Board of Education that came before the Supreme Court. There, a number of black children sued local boards of education, claiming that the denial of the opportunity to go to the same schools where white children attended violated their 14th Amendment. So they were bringing a very similar claim under the same amendment to the Constitution. Lower courts, following the precedent set by Plessy v. Ferguson, were required to, by precedent, rule against the students because they recognized that they could not overrule precedent of the United States Supreme Court. Only the Supreme Court could. And in this case, the Supreme Court did overrule its prior precedent. In considering the impact that separate but equal could have on school children, the Supreme Court said, quote, to separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. Directly addressing Plessy, the court said that whatever may have been the extent of psychological knowledge at the time of Plessy versus Ferguson, the finding that they were then making in Brown is amply supported by modern authority. And they specifically said any language in Plessy versus Ferguson contrary to that is rejected. Thus, the Supreme Court overruled its own precedent and found that separate but equal did violate the Equal Protection Clause. Thus, we see this as an example where sometimes precedent may change dramatically. It's worth noting that there are many who are concerned with the notion that precedent can seem to change based on the times, leading to a debate between those who feel the Constitution itself should be unchanging, interpreted the same way today as it was interpreted 100 years ago, and those who feel interpretation appropriately changes with the times. On the horizon, as more and more justices take the bench, for example, having been appointed by Republican presidents, the future of well-established precedents such as Roe versus Wade, recognizing in our country the right to an abortion, begin to be called into doubt. When Democratic justices are appointed to a bench, or I should say justices appointed by Democratic presidents, there are different precedents that could be called into a question, again, because of the changing dynamic of the court. This has raised a question in our country as to the degree of which precedent should be sacrosanct or subjected to the same political winds that affect the rest of society. However one views these specific issues, it remains true that precedent, or stare decisis, serves a critical function as it permits our citizens to have confidence that our judiciaries will serve as a place of stability in these ever-shifting times. It has certainly been my pleasure to speak to you today. I understand that you've had a very long day, but I'm certainly more than happy to take any questions that you might have on our system on this topic or anything else. Thank you.
Muito obrigado pela palestra. Vamos agora passar, então, para segunda fase aqui, em que possivelmente os colegas terão algumas indagações. Dr. Jorge, em resumo, tratou de dois temas, né, o modo de solução do conflito trabalhista no sistema federal norte-americano, quer dizer, não só no federal, ele acabou ampliando a explanação para a solução de maneira geral, e a questão de como funcionam os precedentes lá. Eu não vou fazer resumo, eu acho que eu prefiro, em vez de eu dizer alguma coisa a título de resumo, eu vou fazer uma pergunta, eu acho, para já a gente não perder essa oportunidade de ouvir o professor Jorge falando, não é? Uma observação que eu anotei aqui, me parece que tem algumas semelhanças do que vem acontecendo no Brasil, é que a agência EEOC, que o professor Jorge mencionou aqui, me pareceu lembrar um pouco as comissões de conciliação prévia que se tentou criar no Brasil através de lei, mas acabou não vingando, mas me pareceu muito semelhante, assim, pela forma como funciona lá. Em relação, ele também explicou os precedentes obrigatórios, os precedentes não obrigatórios, parece um pouco semelhante também ao que a gente chama aqui de súmula não vinculante, né, uma súmula normal como sendo um tipo de um precedente não obrigatório mas que tem uma força persuasiva, e o precedente obrigatório lá com a nossa súmula vinculante, e mesmo o uso dos cases lá também lembra um pouco as consultas que a gente faz aqui aos acórdãos do Tribunal Superior do Trabalho e do Supremo Tribunal nosso para efeito de fundamentação, talvez com a diferença de que a quantidade de acórdãos aqui das nossas cortes superiores é muito maior, eu imagino, do que lá, e isso dificulta muito a nossa... Bom, mas então eu, em vez de falar, eu gostaria de já encaminhar, então, uma indagação. O doutor Jorge mencionou, inclusive, que ele teve um caso lá em que alguns trabalhadores discutiam direitos mínimos, que estariam sendo descumpridos os direitos mínimos, e o professor também mencionou que existe, ao contrário do que muitas vezes se diz no Brasil, talvez a imprensa diz sem conhecimento de causa, de que nos Estados Unidos não existem leis que garantem direitos mínimos ao trabalhador. Então, ao contrário disso, o senhor informou que existem leis que asseguram direitos mínimos. E, repetindo, e que o senhor, inclusive, teve um caso em que se discutia isso. Eu vou fazer uma pergunta, e depois vou passar a palavra também à plateia, depois da sua manifestação. O juiz... e outra coisa, o senhor também comentou que, às vezes, existem empresas lá, ou empresas muito pequenas, ou empresas que não são pequenas, mas estão passando por dificuldades financeiras. Então, a minha pergunta, o juiz, nos Estados Unidos, numa situação de uma empresa muito pequena, ou uma empresa com dificuldades financeiras, ele pode reduzir, de alguma maneira, autorizar a redução desses direitos mínimos previstos na lei americana?
So that's a very good question. So the way that it works in the American system, to address your earlier point, there are laws, both federally and in the state system, that provide for specific amounts that must be paid as a minimum wage. And where you sometimes will hear the media or politicians arguing about things, it's not whether there should be any minimum wage, it's what the minimum wage should be. And so I think that's probably what you might be hearing in terms of the media saying different things, arguing about different issues. It's not whether or not it should exist, it's just how high it should be. In terms of your question, the way that I would process, and did in fact in the case that was before me, the issue that you raised, at the very least, the employee is going to be entitled to the amount of wages that the law requires. So there wouldn't be any basis for me to say, well, I'm deciding that they owed her back wages, once I've done all the math, of $100,000, but I'm going to reduce it because I find that this company would go bankrupt if they had to pay that. It's not for me to make that determination as an initial matter. I just determine this is what is owed. Now, there are other provisions in the law that says if, for example, the company was acting in bad faith, right, which is to say, for example, that they knew that they owed this person that money, and just for whatever reason, they were making a decision not to pay it, I can double the damages, or in some situations, triple the damages, and say, not only am I rewarding her or him, it's often with the restaurant workers, females, but her or him, not only am I awarding them what they were owed, but as somewhat of a penalty against the company for acting in bad faith, I can say, I'm going to double or triple the amount that's owed. So to the extent that I would be in a situation where I would have, for some reason, reasons to be sympathetic towards the defendant, the company who was doing the best they could, that just might be a situation where I would not issue what we call treble damages, which is triple the damages, or penalties against the company. But I would have to at least order the money that she was owed. I couldn't reduce that. The money, if I decided that she was owed the money, then that's what the judgment's supposed to be for.
Eu queria cumprimentar o Judge George Hazel pela palestra, que, de forma tão didática, expôs um pouquinho do intrincado sistema judicial americano e do uso de precedentes. Eu queria ouvir do senhor a respeito das class actions em matéria trabalhista, onde são propostas, se em nível federal, e quais são as matérias que são mais tratadas nas class action. Obrigada.
Sure. So as a general matter, we do occasionally get cases just throughout our system for any number of reasons where it makes more sense to have someone or a group of plaintiffs proceed as a class. And we probably have requirements that are similar to the requirements that you might have in terms of the claims being similar, the theories being similar, making a decision that it would be more efficient to approach it that way. In the context of the FLSA, which is our labor law, our Labor Standards Act law, we refer to it as a collective action. So we just use a slightly different terminology. But we do have those cases. It is often more efficient than proceeding on a case-by-case basis with 10, 15, 20 individual cases. The other thing that we find, and this isn't just true in the labor context, it's true throughout our system, is that sometimes when you bring a class or collective action, the benefit you have there is that an attorney who might otherwise not be interested in taking the individual case, because that's going to be a lot of work for one individual case where you're going to collect money from one individual or collect money based on one individual's payments or owed payments. If you can bring a group action, a collective action, it might inspire an attorney who might not otherwise be interested to become interested and bring the claim. And so we often see that the attorneys are better in cases where it's a collective or class action. And so that's one reason why courts often appreciate that. But it is something that we do see in our labor cases. We call them collective actions in FLSA cases, just because the rules are slightly different from the rules that we apply in other actions. But we do make great use of that. The plaintiffs bring those kind of cases. I wouldn't say frequently. A typical judge might have one or two of them at a time. But the judges, those cases are brought before our courts. I will say, I guess you all are used to this, but I'm looking at him and hearing this very nice female voice, and it is a little.
Eu queria saber. Que ele falou em publicar as opiniões, né, que são publicadas. Vamos dizer, que nós temos aqui o caso do Gilmar Mendes, não sei se ele tem acompanhado, né, que ele tem opiniões sobre todos os julgamentos e fala na imprensa. Se é nesse sentido, como é que é essa questão de eu publicar opiniões? É antes do julgamento? Eu não entendi essa passagem.
Sure. So when I'm talking about a published or unpublished opinion from a judge, I was referring primarily to an appellate court case. So we do have the ability at the trial level to, as we say, publish or unpublished decisions, but they really have little impact on anything because our cases are usually not going to be precedent in any event. There are times where we'll issue opinions at any number of stages before or after the trial. We might be dismissing a case before the trial. We might be dismissing a case after the trial because the jury ruled one way and we just didn't think the evidence supported it. But when I was primarily focusing, what I was primarily focusing on before in distinguishing between published and unpublished opinions is when a court of appeals issues an opinion. The Supreme Court, whenever they issue an opinion, it's going to be quote-unquote published. The Circuit Court of Appeals sometimes will just have a little designation as they issue an opinion indicating that it's unpublished. And I think the point I was trying to make is that one shouldn't give, particularly in this era, too much weight to that or assign too much importance to that. Technically, it will say an unpublished opinion is not binding. That's often language that will be on there. But as a lower court, if I see an unpublished opinion from the Fourth Circuit Court of Appeals, I'm going to follow it because I know that if my case gets appealed, that's how they're going to interpret my case because they've already told me. And so it's a distinction that is made that was worth noting to the extent I was trying to draw some distinction between our process and your process where there seems to be some formal method for deciding what is or is not binding precedent. The only comparable thing we have is the frankly, I think, less significant distinction that appellate courts make sometimes between saying, I'm going to designate this as a published opinion versus an unpublished opinion. Whenever, as I indicated, whenever there's an issue they're deciding that they haven't previously decided, they're going to publish it. It's really only if they are looking at an issue that's been decided before and, don't repeat this to any of my colleagues on the Fourth Circuit, it might just be maybe they can proofread it one less time if they're going to mark it unpublished than they might have if they were publishing it. But beyond that, there's not a real significance. It's not like in your process where there's a significance to someone actually saying this is going to be precedent or this is not going to be precedent.
Eu tenho outra pergunta. A gente sabe que na justiça americana, a questão da responsabilidade civil, principalmente na iniciativa privada, é muito forte. Há condenações milionárias envolvendo grandes empresas, enfim. Como é que isso se dá em relação às questões trabalhistas? No Brasil, há uma crítica muito grande de que há uma certa banalização dos pedidos de danos morais nas ações trabalhistas. Como é que isso se dá no sistema americano e como é que são as condenações em relação aos danos morais praticados por empresas?
I'm sorry, could you repeat that? I'm not sure I understand. You used a word I wasn't sure I was familiar with. Could you?
I think like...
Sure, either. Yes, I was a little confused by the word banalization, but I think I understand what you mean by that now. Right, got it. That's what I figured. So in our court, employment discrimination is something that we take very seriously. It hasn't always been the case. And so it was, I want to say it was in the 1960s as part of the Civil Rights Act. I mean, if you're familiar with American history generally, and that's not the topic for the day, but the 1960s was a time when civil rights was a focal point for the United States. Dr. King, Dr. Martin Luther King, and others at that time were really focused on that issue. And what came out of that time were laws such as our Civil Rights Act, which impacted how we looked at things like employment discrimination. So I think part of it is because of our history. It's been such an issue, and I'm not as expert obviously on your history, but it's been such a part of our history, discrimination between the races, that it's certainly something that's taken very seriously now when there's an allegation either based on race, gender. Now we see a lot of cases based on sexual orientation. If we see that somebody is being discriminated against, which can mean based on salary, can mean being fired, can mean just mistreatment, just depending on the situation, it's something that we do look at very seriously. And it's a significant portion of our caseload.
Hello, Judge. Once again, thank you very much for being with us here. Thank you. You have been so kind with us. Besides your trouble with your flight, you just arrived, came here, and we appreciate it a lot. Thank you. She asked also about the no pecuniary loss. How do you treat it in your system about the employment cases?
When there's no actual, I'm sorry. When there's no loss?
Yeah, no
No financial loss, no actual
financial
money
loss,
being
yes,
lost?
Yes.
And are you referring in the labor situation or in discrimination or both?
Yes. Both.
Yeah, I mean, so usually we end up having to make things an issue of dollar and cents. And often if there is no damages, if there is no money involved, you know, sometimes cases can get dismissed because there are no damages. But oftentimes, particularly in the discrimination context, we have something that's called nominal damages. And that might be a situation where the actual dollar amount really isn't that significant, but the principle involved is. And, you know, oftentimes plaintiffs might not be interested in bringing those cases. That actually, to go back to the earlier question, sometimes that's when you see a class action case, because each plaintiff might only be out $10, but if an employer has been doing that to all of its employees for 10 years, then the principal is worth more than any particular loss to any particular plaintiff. So that's one time where that becomes an issue, where we say, no, this is an important case because there's a principle at stake here. Same thing in a discrimination context. Sometimes it might be hard to actually point out, all right, what did the plaintiff actually lose? And if there really is no damage, then they don't have a case. But there can be, and this isn't just in the employment case, there can be situations throughout our law where we say, look, it's hard to pinpoint a dollar amount. Sometimes juries will actually come back with a verdict of $1, but it's still a verdict in favor of the plaintiff, saying that the defendant's discriminated against them, and that might still be important enough to cause the defendant, or in some cases, to get what we call injunctive relief, ordering the defendant to change its policies, to change how they do things. And so something important has been achieved, even if there's no actual dollars and cents, or at least not a high number of dollars and cents actually at issue. And in terms of my travel here to get, again, it's been my pleasure. The honor and privilege is mine, but I appreciate you being so kind.
Gostaria de parabenizar também e perguntar sobre a forma de ingresso na magistratura. Eu sei que fazem eleição, mas eu gostaria de saber quem que elege e por quanto tempo o magistrado fica no cargo e quais garantias que tem.
That's a good question, and it depends on the type of judge. So a state judge gets appointed by the governor of their state and then actually does have to sit for an election. And I believe it's every 15 years. So you have to, again, this is a state judge, upon being appointed by the governor, whenever the next election comes up, you sit for the election, and then every 15 years after that, you sit for another election. So for most people, unless they get appointed really young, there's one election in 15 years. By the time the next one comes around, they're usually ready to retire. The federal system is very different. We're not appointed by, there's no election involved at all. We have lifetime appointment. So once you're appointed to the federal bench is what we call an Article III judge, which is a federal district court judge, which is what I am, a court of appeal judge, or the United States Supreme Court. All of those are a lifetime appointment. So we can't be removed unless we are impeached, which involves, you know, an act of Congress. So that's not something that happens very often at all. So, you know, you can't beat being a federal judge for job security. You can definitely say that.
Eu tenho uma curiosidade, gostaria de saber, quando o senhor está analisando um caso, está fazendo um julgamento, e o senhor verifica que o precedente é contrário à sua convicção, à sua formação, e como que o senhor procede?
No, that's a good question. What I take you to mean is if I read a case from the Fourth Circuit Court of Appeals, and in my mind I say, I think that's wrong. It happens, and I'm sure it happens here. You know, I have to follow it, even if I think it's wrong. Now there might be times, and you have to be really careful about this, because it's, you know, it's a fraternity. You know, there might be times where you might indicate in your opinion that I'm following this only because I have to. And I wouldn't say that a lot because it probably wouldn't be considered good form for me to say it a lot. But But if I felt strongly enough about it, I might say in the opinion that although this might not be how I would come out if given the opportunity to rule on a clean slate, the Fourth Circuit has spoken on this issue, or the Supreme Court has spoken on this issue. I have to follow it, and so that's why I'm ruling the way I'm ruling.
Deixa eu só eu fazer mais uma indagação aqui. Um problema que inferniza a vida dos juízes aqui é a quantidade de ações individuais sobre a mesma matéria. Então, a minha dúvida é se é possível acontecer isso com, digamos, com o juiz federal nos Estados Unidos, de receber uma quantidade grande de ações individuais sobre a mesma matéria, e se é que isso é possível, se o juiz ali, se o senhor, por exemplo, teria como alguma forma de reuni-las todas para uma decisão só, ou escolher uma delas para dar uma decisão padrão que valeria para as outras. Essa é uma dúvida.
So the only court in our system that gets to choose its cases is the United States Supreme Court. So the United States Supreme Court doesn't decide the same issue twice unless they're getting ready to overrule it, or if they actually see something about the second case that's different from the first case that they feel is worth making a distinction for. So the only court that gets to choose its cases is the United States Supreme Court, at least in the federal system. In the state system, I think the Court of Appeals sometimes has some discretion. So to answer your question, I don't get to say, I've seen this issue before, so I'm not going to address it. What I can do, and what I do sometimes do, you know, when I get an issue that hasn't come up before, you know, that might be an opinion that reflects a certain amount of detail, a certain amount of effort, a certain amount of thoughtfulness. Some of my opinions can be 10 pages, 15 pages. I've had some 25, 30 pages. Those tend to be the opinions in the cases where it's a new and interesting issue. And then if I get one where I say, you know, this question has been answered by me, by the judge down the hall, and more importantly, by the Fourth Circuit Court of Appeals, there's really nothing to discuss here. It's directly on point. You know, it doesn't happen often, I will say, to credit the lawyers. Then, you know, that might just be a very short opinion that I'll write. I will say, however, that we do have ethical rules, and this probably best answers your question, actually. We do have ethical rules that say that an attorney has to have a good faith belief that they have a case that has merit in order to bring the case. So if an attorney has a case where they say, you know, I'm going to say, you know, that this happened and my client should be able to bring a lawsuit based on these set of facts, and there are 5 cases that have already said, no, you can't on that set of facts, then that lawyer, I still have to deal with the case, but that lawyer might actually face a problem with the bar. You know, there might actually be a sanction placed against the lawyer for bringing a case that he clearly didn't have a good faith belief in. And we actually do that from time to time. Sometimes where we have people, we get this a lot in our foreclosure cases, in our mortgage cases where somebody's about to lose their house, and so they'll have someone file something to try to stop the foreclosure proceeding, and it's something that the courts have said a number of times that's not a basis to stop the foreclosure. You're just trying to stall, you're trying to delay, you're trying to harass. At some point, we'll warn the attorney, if you bring a case like this again, we're actually going to report you to the local bar and suggest that a sanction be brought for bringing a case that you yourself could not possibly have actually believed in. So that's how we deal with that issue. Yes, a judge, and it's not something we do often. The question was, can you find a lawyer? And the answer is yes, we can. We can hold a lawyer in civil contempt. We have Rule 11, which is a rule of civil procedure that goes sort of toward the issue I was just discussing. So we absolutely can. It's not something that we do often, and I don't think it's something that people suggest judges do. I think what happens more often is that we will refer the attorney to the local bar and allow the local bar to deal with it.
O advogado, para atuar na sua jurisdição, o senhor precisa autorizá-lo? Ele precisa ter autorização sua para atuar nos processos? Eu não sei se o senhor entendeu a pergunta. É porque nós temos aqui no Brasil, ouvimos alguma vez essa informação, de que para o juiz, para o advogado poder advogar numa determinada unidade judiciária nos Estados Unidos, ele precisa como se cadastrar, não sei se apresentar ao juiz e o juiz autorizar que ele advogue ali. Eu não sei se procede essa afirmação.
So that's an interesting question. So we don't have anything where, in every case, we have to sort of approve Attorney X to be able to practice in this particular area. There are some areas where, say, in criminal law, we have attorneys that we appoint to defendants who cannot afford attorneys, and you certainly have to pass a certain level of competence before we do that, because that's just how much we care about individual defendants receiving good attorneys. But typically, in civil cases, the plaintiff or defendant chooses their attorney. And so it's sort of a selection process. I'm trying to think of the best word to use for it. It's sort of a market-driven process, I guess is probably the best way to say it, where attorneys develop strong reputations in certain areas of the law. They develop a reputation for being great in the class action arena or great in the Fair Labor Standards Act arena. And so they advertise themselves, or more often, frankly, through word of mouth. And so people tend to gravitate through those attorneys. But we don't really have a system where we would say, this attorney we decide is not competent enough to handle this kind of case, because ultimately the parties in our cases have the right to choose their own attorney. And so if they choose an attorney that's not what we might think is the best attorney for them, we tend not to want to really sort of invade upon that individual's opportunity to choose the attorney they want to have represent them. It's only if there's a situation where we are appointing an attorney because the person cannot afford an attorney. And so in that situation, because we are actually appointing the attorney, we're going to make sure that we're appointing someone who has the competence to deal with the issue that they're handling. But I think that's the only circumstance I can think of when we are actually appointing an attorney and deciding ourselves in advance whether we think that attorney is competent to handle the issue.
No Brasil, o Estado apresenta centenas, milhares de recursos contra a súmula. Mas é uma questão ética, né, como o Dr. Jorge colocou. Mais alguma indagação? Eu acho que, então, diante do horário, o pessoal já deve estar meio cansado, estão o dia todo, aliás, desde ontem aqui. Eu quero, antes de encerrar, então, agradecer mais uma vez, em nome da escola, do Tribunal de Santa Catarina, agradecer ao Dr. Jorge pela gentileza, pela disposição em viajar até aqui, enfrentando todas essas dificuldades que acabaram surgindo de viagem. Mesmo assim, ele concordou em alterar o voo e tudo. Queremos, então, deixar nosso profundo agradecimento por essa oportunidade que vem enriquecer muito nosso aprendizado aqui da escola, num momento em que nós estamos passando no Brasil de muitas mudanças na legislação e nos últimos anos, né? e onde essas mudanças nas leis têm, muitas vezes, trazido para o sistema de direito do Brasil mecanismos do common law, mecanismos que são tradicionais no sistema inglês e americano, mas que para nós é uma novidade. Eu até mencionei que, há uns anos atrás, tentou criar aqui uma comissão administrativa de conciliação prévia que deveria ser acessada pelos litigantes antes da ação judicial, mas, por uma questão cultural, outros problemas, acabou não... Então, essas informações são muito valiosas para nós. Então, eu agradeço em nome da escola. Eu queria entregar ao professor Jorge, então, um certificado de participação. E, em seguida, eu vou devolver a palavra à cerimonial, né?